Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about the SC and ST Prevention of Atrocity Act 1989. Let's see the meaning of atrocity. Atrocity is an expression commonly used to refer to crime against SC and STs in India. It denotes the quality of being shockingly cruel and inhumane, where the term crimes relate to the act punishable by law. It also implies any offences under the Indian Penal Code committed against SC and ST by a non-SC and ST person. Now let's see the objective of this act. The objective and purpose of this legislation was outlined by when the bill was being introduced in Lok Sabha. Despite various measures to improve the socio-economic condition of our SC and STs, they remain vulnerable. They have in several brutal incidents been deprived of their life and property. And because of the unawareness created through spread of education, when they assert their right and resist the practice of untouchability against them, or demand statutory minimum wages, or refuse to do any bonded or forced labor, the vested interests try to cow them before they terrorize them. When the SCs and ST try to preserve their self-respect or honor of their women, they become irritant for the dominant and mighty. Under the circumstances, the existing law, like the Protection of Civil Rights Act 1955 and the normal provision of the Indian Penal Code, have been found to be inadequate to check and deter crimes which were committed by the SC and ST. It is considered necessary that only the term atrocity should be defined, but also stringent measures to be introduced to provide for higher punishment for committing such atrocities. It is also proposed to enjoin the state and union territories to take specific prevention and punitive measures. Now let's see the salient feature of this act. Starting with the creation of new types of offences which were not included in the Indian Penal Code or in the Protection of Civil Rights Act 1955. Then the next is the commission of offences only by a specified person, that is, barbarity can be committed by only non-SC and ST. Then the next is defines various types of atrocity against ST and SC under Section 3 Clause 1. Moreover, it prescribes strict punishment for such atrocities and with the enhanced the quality of the punishment for some offences. It also enhanced minimum punishment for public servants and penalty for delinquing of the duties by the public servant. Moreover, the attachment and forfeiture of the property were also provided, externment of potential offenders, and the creation of special court were there. Moreover, the appointment of special public prosecutor was also provided in this act, along with the empowerment of the government to impose and collect fines. This act also ensured that the arms licenses in the area labelled when an atrocity may take place or has taken place and the collapse and illegal firearms. Also provide the grant arms license to SC and ST and the denial of any anticipatory bail or the denial of probation to the convicts. Now let's see the SC and ST Prevention of Atrocity Act 1989 in brief. Starting with the definition, Section 3 provides of this act of the definition of atrocity, code, scheduled tribe and scheduled caste, special court, special public prosecutor, and also discuss about the amendment made in this act. Then the next is the punishment clause. Section 4 of this act provides the punishment for offences of atrocities. If an offence is being committed by the upper caste member upon the lower caste, such person shall be liable for punishment under Section 4. Then the use of forces against Dalits. Section 3 Clause 1 provides specific offences of atrocity by the use of forces. If a member of any upper class use force against a member of the scheduled caste or tribe, like forcing him into drinking or eating anything which is inedible or filthy in nature, or may provide injury, insult or annoyance to any member of the SC or ST, or try dumping excrete, waste material or corpse on the other, will be considered as offensive substance in its premise or neighborhood, or forcibly removes clothes for the person of a member of SC and ST. Then the next is wrongful possession. This act provides that if any SC and ST Wrongfully occupies or cultivated any land owned by or allotted to or notified by the competent authority to be allotted to the member of the scheduled caste and scheduled tribe, or gets the land allotted to him transferred, shall be liable for minimum mandatory punishment of 6 months, which may extend to 5 years, and shall be also be liable for fine. Then the next is against beggar or bonded labor. If the atrocity compels or persuade a member of a lower caste or Dalit to do begging or any other similar form of forced or bonded labor, or any other which is being provided in the compulsory service of public purpose imposed by the government, shall be liable for minimum mandatory punishment of 6 years, which may extend to 5 years, and will also be liable for fine. Then the next is to force to vote. If any scheduled caste or scheduled tribe been forced or intimidated a member of a scheduled caste or tribe not to vote or to vote to a particular candidate in a manner other than provided by the law, will be liable for minimum of punishment of 6 years, which may extend to 5 years, and shall also be liable for fine. Then the next is causing humiliation in public places. If any upper class of society try to insult intentionally or intimidate with intent to humiliate a member of SC or ST in any place within a public view, shall be liable for minimum mandatory punishment. Then the next is assault with intent to outrage the modesty of a woman. If at any time the upper class assault or use forces to any woman belonging to SC or ST with an intent to dishonor or abuse her modesty, will be liable for minimum mandatory punishment of 6 months, which may extend to 5 years, along with fine. Now let's see the amendment in the Act. The Prevention of Atrocity Act was altered by the previous UPA government in March 2014. Let's see the major amendment in this Act. Starting with the rationalization of the phrasing of relief amount payment to victim for various offences of atrocity. Next is not linking remittance of any part of relief amount with the requirement of medical examination for non-invasive kind of offences against women like sexual harassment, gesture, or act intended to insult the or outrage the modesty of a woman. Next is provision of relief for offences of rape and gang rape. The next is rise in the existing sum of release amount depending upon the nature of the offence while linking it to the consumer price index for industrial workers. Moreover, the amendment provides for the new offences of atrocities like tonguing of head, mustache or similar act which are derogatory in nature, or gargling with chappals, or denying access to irrigation facilities or any of the forest right, or dispose of carry human or animal carcass, or delegating any SC/ST woman as Devadasi, or abusing in caste name, or imposing of social or economic boycott, or preventing SC and ST candidate from filing or nomination to contest election. Moreover, any hurting to SC and ST women by removing their garments, along with forcing a member of SC/ST to leave house, village or residence. Now let's see the exclusive special court for speedy justice. This amendment also provides the authorized establishment of exclusive special court and appointment of exclusive special public prosecutor to try the offences under this Act. This is made to enable the speedy justice and immediate disposal of the cases. Moreover, the amendment also enhanced in the relief amount. The standard for relief amount was also been justified, including enhancement of the relief amount for certain offences. A new chapter of the right of victims and witnesses have also been added to the Act. The term willful negligence of public servant at all levels, starting from the registration of complaint and covering aspect of the dereliction of duty under this Act, has been clearly defined. In the last, the presumption of the offences which has been added to the Act, that is, if the accused was acquainted with the victim or any family, the court will presume that the accused was aware of the caste or tribal identity of the victim unless provided otherwise. That is all for today's video. Thank you for watching. Please like, share and subscribe.